The purpose of the Hayek is not just to give an award, it's to highlight a problem. What is the big theme this year? And it's the administrative state, it's bureaucracy, and it's encroachments. There's the government you vote for, but then there's the government that's there regardless. You have no choice. The problem started in the first progressive era, in the time of Woodrow Wilson, and then in the New Deal of Franklin Roosevelt. First one bureaucracy, then two, then 20, then 50. They're like boulders in our path, and yet we cannot question them or unelect them. Hayek wrote in The Road to Serfdom, a boss might be a burden upon an employee, but far greater than any boss or any millionaire was the bureaucrat. In the progressive era, the idea was we should put the smart people in charge. Hayek got at that smarter is not always better.
One of the dominant ideas is the idea that we can design social institutions in their working. Social institutions have never been designed and do much more than we knew.
Knowledge comes from strange sources, it grows organically, and even the smartest of the smart cannot always anticipate the best solution. Which books talk about this? Which books show how it might be better? Which books challenge the administrative state? Philip Howard's The Rule of Nobody is the book that explains why administration is objectionable. When rules take over, people are second. And he works very, very hard to capture the absurdity of our everyday life and says, you don't just have to live with this, you have to identify it and then begin to object to it. How has our liberal freedom been lost? Epstein traces that loss case by case. If you want to know how it happened, Epstein is your Bible. Sometimes we think about bureaucracy, there is no alternative. What Stringham shows is that within the United States, all the time, little examples of private governance are functioning, are beautiful. What Cesar Hidalgo shows in this book, and so brilliantly, is that information grows by itself. Bureaucrats, in fact, get in the way. Ideas spread by themselves. This is what we know intuitively, but Hidalgo traces it with a fine line. It's a joy to read this book. The logic of the market uses Hayek's philosophy to examine China. It shows that where the growth is just political, that's not real growth. And thereby reminds us, as Hayek did, that administrators aren't the answer, innovators are. The jury thought about it, and we chose Philip Hamburger and his book, Is Administrative Law Unlawful? With his axe, Hamburger whacks the original root of the big tree of administration. It's not part of our Constitution, and he makes that case with the incredible authority of a strong law professor, and we've been lacking that book. Here it is.
I think administrative power is the civil liberties issue of our era. One of the most fundamental aspects of our liberty is that we have our laws made by representatives and thereby with consent. But there is this government within the government, an administrative state, that is largely unaffected by elections, that exercises power over us through its own system of legislation and its own court system. That movement against administrative power is going to be a tough battle. So I'm most grateful for the Hayek Prize because it will help get the word out.
A figure like Philip Hamburger is really necessary. Young law professors need to follow him. This prize says you're not alone if you think freedom is important. Welcome to our community of courage. You belong with us. We think we can make some progress.
Thank you very much, Larry. Tonight, we're honoring a book that could not be more timely or important. Administrative law It may sound remote and abstract, but that's only until you see the harm resulting from its abuse. Our country's founders fought a war and they wrote a constitution to stop this abuse. Yet today it threatens us more than ever before. I'll give you just one example. In 2010, an assistant secretary at the Federal Department of Education heard a radio report about a purported crisis. The report was produced jointly by NPR and by a group named, rather misleadingly, the Center for Public Integrity. The report claimed that there was an epidemic of sexual assault on campus that was being cavalierly ignored by school administrators, by police, by federal officials. It was a textbook example of journalism that doesn't let the facts get in the way of the story. It offered absurdly inflated statistics, junk science at its worst, along with an alleged horror story from one school that was later soundly debunked. But by then it didn't matter. That one unelected and misinformed functionary at the Department of Education was so moved by that report that she single-handedly stripped the rights of millions of college students. She didn't bother consulting with Congress. She didn't even bother following her own agency's policy of giving the public a chance to comment on proposed regulations. Citing Title IX, a law that had never been intended for this, she simply wrote a letter to colleagues, and it was called Dear Colleagues, this infamous letter, ordering colleges to start hearing sexual assault cases in special courts designed according to her rules. Rules that, as the Harvard Law faculty said, lacked the most basic elements of fairness and due process. The result has been dozens of lawsuits against colleges and countless genuine horror stories by students whose lives have been ruined in these new versions of the Star Chamber. Now, that bureaucrat's letter is considered the law of the land, but is it actually lawful? That's the question brilliantly addressed by tonight's winner of the Hayek Prize. Philip Hamburger is a superb scholar of constitutional law and history. He's the Morris and Hilda Friedman Professor of Law at Columbia, and he is the author of two previous books, Separation of Church and State and Law and Judicial Duty. Tonight we honor his latest book, Is Administrative Law Lawful? That is a sweeping historical analysis showing how today's edicts from Washington are remarkably similar to decrees from English kings who asserted that they had a prerogative to act unilaterally. Their subjects beg to differ. And these decrees were gradually curtailed by English constitutional law and then later by the United States Constitution. Now, but since the Progressive era, as Amity said, and especially during the current administration, we have seen more and more officials in Washington who are reasserting that royal prerogative to act on their own. And Dr. Hamburger brilliantly demonstrates this in his book. His achievement is summarized by Gary Lawson of the Boston University School of Law, who writes, "With characteristic erudition, Philip Hamburger shows how virtually every aspect of the modern administrative state undermines the Anglo-American legal tradition and the ideas that the American Revolution was trying to reject." Now, these ideas were also rejected by Hayek, who warned of what he called the fatal conceit, the delusion by kings and other central planners that they possessed all the knowledge necessary to rule their subjects. Giving them unrestrained power, Hayek realized, was the road back to serfdom. So it is especially fitting tonight that we honor with the Hayek Prize someone, a scholar, who has a very different road ahead. Ladies and gentlemen, Dr. Philip Hamburger.
I want to begin by expressing my gratitude. I'm deeply moved by this prize. It is personally satisfying, but it also is more broadly important because it will draw attention to the danger from administrative power. Incidentally, this prize is especially meaningful for me because my parents knew Hayek. My father did his PhD under Hayek at Chicago, and my mother, who was Ronald Coase's research assistant in England, knew the Hayeks there. But I'll spare you the stories. My thesis is that administrative power is unconstitutional. Indeed, it is the central civil liberties question of our time. Many people understand there's a problem, but few understand just how serious it is. Administrative power returns to absolute power, to the very power constitutional law developed in order to prohibit. It thus returns to a pre-constitutional mode of governance. Many folks fear that conservatives are originalists who will seek a return to the past, back to 1789. But my argument is that we already have returned to the past. Not to this constitutionalism of 1789, but actually more to about the absolutism of, say, 1610. Administrative power thus restores the central constitutional danger that constitutional law was designed to defeat. And once this is understood, it becomes clear that administrative power is utterly unconstitutional. In sum, this is a legal argument. Although we still have the shell of a republic, administrative power creates within it the very sort of government absolutism that constitutional law was expected to prevent. As an introductory matter, I should explain what sets my argument apart, what makes it different from the usual economic critiques of administrative power. During the past century, most complaints about administrative power have been from an economic perspective. These are the complaints that administrative power is inefficient, that it is dangerously centralized, that it produces too much regulation, that it's too burdensome, that it stifles innovation and growth. And all of this is true, painfully true. But these are economic complaints, and economic complaints cannot be the entire critique of administrative power. They are not apt to persuade persons who do not understand economics, and they're not apt to persuade judges whose training and duty is to focus on the law. Indeed, the economic complaint tends to accept administrative regulation that is not especially burdensome, and it thereby often accepts the legitimacy of administrative power and merely protests its extent. The economic critique, therefore, has not stopped the growth of administrative power. On the contrary, administrative power has expanded with each decade. So we have to reconsider the critique, or at least add to it. And it therefore is essential to pay attention to another sort of argument, one based not on economic costs, but on law. It is true, much administrative power is economically inefficient. There's no doubt about that. But all of it is unconstitutional. Indeed, it is a gross violation of constitutional law, a profound threat to constitutional rights, and one of the greatest threats to civil liberties in the nation's history. This is a much more complete and more legally effective argument, and I'm glad to say it is beginning to gain traction among lawyers and judges across the nation. This talk comes in three parts. First, I want to give some examples of absolute power, both then and now. Second, what do I mean by absolute power? And then third, how does the U.S. Constitution reject this sort of power? First, let's look at some examples of absolute power then and now. Part of my argument is that administrative power revives absolutism. To illustrate the revival of absolute power, let's look at some examples in the past and then the present. And let's begin, of course, with James I. Of course, James. He was an academic, so no wonder, right? He was King of England from 1603 to 1625. And unfortunately for the English, he openly exercised absolute power. He was not content with the government's power, its regular power to make statutes in Parliament or to have cases adjudicated in the courts. No, that's not good enough for James. In addition, he wanted to exercise extra legal versions of these powers in his prerogative or administrative agencies. And this extra legal power in his agencies is what we call administrative power. It's what they called absolute power. His prerogative over administrative agencies most famously included the Star Chamber and the High Commission. These bodies are often associated with blood-soaked torture chambers, as if all they did was use the rack, the thumb screw, and the rest. But in fact, they were more bureaucratic than bloody. Rarely did they use torture. Mostly, they just used bureaucracy. They were efficient administrative agencies that commissioned expert reports and then made and enforced administrative regulations. Sounds familiar? Instead of legislating through acts of parliament, James used the Star Chamber to issue binding proclamations or regulations on trade, manufacturing, and urban development. But the judges in 1610 declared such proclamations unlawful and void. Unlike today, the judges recognized that lawmaking outside of the legislature was unlawful. James also used the Star Chamber and High Commission to evade the courts, to substitute administrative process for the due process of law. And when his prerogative or administrative agencies interpreted statutes, he demanded judicial deference to their interpretations. But the judges again understood better. They generally refused to defer. Chief Justice Cook in 1608 told James that he lacked judicial office, and the judges had the office of judging or interpreting. The judges, therefore, could not defer to the interpretations of his administrative or prerogative agencies. In other words, no Chevron deference for James. In such ways, James used his agencies to exercise what then was called absolute power, and the judges, at least sometimes, condemned it as unlawful. Now, let's look at some contemporary examples. Sadly, the problem comes from presidents and other politicians, as well as kings, and indeed from both parties. It's hard to blame either party. Each almost competes sometimes to be more abusive in their use of administrative power. Like James, they want to govern us not by statutes made by the legislature, but by administrative rules and interpretations, and not through judgments made in courts, but through administrative adjudication. An example of administrative lawmaking can be found in the Affordable Care Act, which expressly authorizes Health and Human Services to make rules on health care. Other examples of administrative lawmaking can be found in almost all federal agencies. There are literally hundreds of agencies that do this, that make law outside of Congress. An example of administrative interpretation is the Clean Power Plan. This is an EPA rule designed to reduce greenhouse gas emissions by establishing emissions standards for existing power plants. Most commentators protest its substance, and rightly so. But what I want to focus on is the method of making the rule. The EPA claims authority to make this rule on the theory that it is merely interpreting an obscure section of the Clean Air Act, and that courts must defer to its interpretation, Section 111D, if you really care. This is what's known as Chevron deference, named after a 1984 case, Chevron versus National Resources Defense Council. And it dangerously empowers agencies, because wherever Congress doesn't speak, the agency can simply say it's interpreting and thereby creates law. Another example of this administrative interpretation is the EPA rule on waters of the United States, an EPA rule that ambitiously controls almost all waters in the nation, perhaps even the moisture on your forehead. Really. Anything that's damp is potentially covered by this. Yet another example is the Department of Education's interpretation of Title IX, which was mentioned, the Dear Colleague letters, in which the department uses this interpretation to control speech on campuses. Finally, there's administrative adjudication, and this can be illustrated most beautifully by the Securities Exchange Commission. The SEC can refer insider trading cases to the Justice Department for it to prosecute criminally in federal courts, where defendants get judges and juries and the full constitutional range of procedural rights. But the SEC can also pursue such cases administratively before administrative law judges, who work for the SEC, who are not judges, who do not offer juries, who give only a fraction of the due process required in courts. I call this not due process, but faux process. All of this is administrative lawmaking, interpretation, and adjudication, and it constitutes the new absolute power. Rather than be confined merely by Congress and the courts, Americans nowadays are also restricted or ruled by administrative agencies. Okay, now let's shift gears. Let's move from examples to a conceptual inquiry. The second part of this talk asks simply, what is absolute power? The phrase absolute power is often used as a term of abuse, but it traditionally had very specific meanings. And one of these is especially important for us in understanding administrative power. For our purposes, the key point is that absolute power was extra-legal power. in that it bound not through law, but through other pathways or other mechanisms. Anglo-American law traditionally established clear avenues for binding persons. You had to either have an act of the legislature or an act of a court. Otherwise, there's no legal obligation. These were the only ways of creating legal obligation. Nonetheless, absolute power bound persons through other paths, and in this sense, absolute power was extra-legal. Kings, for example, bound the English not merely through statutes, but through their proclamations and their bureaucracies, regulations, interpretations, and adjudications. And presidents and their bureaucracy now do the same thing again. Now note, in saying that absolute power was extra-legal, I do not mean simply it was unlawful or is unlawful or contrary to law. That doesn't even begin to capture it. Rather, it's extra-legal in the sense that it binds or obliges people through means other than law. Put another way, in simple terms, administrative power or absolute power evades the regular avenues of power. Third, and finally, administrative power is unconstitutional. Now, how does the US Constitution bar administrative power? It doesn't have that administrative power section that says, no, don't do that. It doesn't have that section. But it does have some sections that are very revealing. First, the Constitution establishes only regular avenues of power and thereby blocks extra-legal or administrative power. The Constitution rejects extra-legal lawmaking by placing legislative power in Congress, and it rejects extra-legal adjudication by placing judicial power in the courts. Second, the Constitution protects procedural rights to bar administrative or other extra-legal adjudication. Most of the Bill of Rights actually is not substantive. Most of the Bill of Rights consists of procedural rights. And it protects such rights not only to set standards for the courts, but also to preclude alternative modes of adjudication. So, for example, due process of law is not merely a standard for the courts. It's a bar against administrative power. Jury rights are not merely a standard for the courts, but an obstacle to administrative power. In fact, almost all procedural rights were designed as barriers to administrative power. The Supreme Court obviously has forgotten some of this, but that just makes it all the more our duty to remind them. Third, administrative lawmaking is justified as delegated power. But this delegation is actually expressly barred by the Constitution. Cass Sunstein, a former colleague of mine, asks, where is delegation barred by the text? Now, whether he really cares about the text is an interesting question, but we can leave that for another day. If one really cares about the text, one actually need to look no further than the very first substantive word of the Constitution. The very first substantive word, all. All legislative powers herein granted should be vested in a Congress. If all legislative powers are in Congress, they can't be elsewhere. If the grant were merely permissive, not exclusive, there would be no reason for the word all. The word all bars delegation. Fourth, the necessary and proper clause bars the rearrangement of government powers. The necessary and proper clause authorizes Congress to do what is necessary and proper to carry out the government's other powers. And it therefore is usually thought to allow Congress to create administrative power, to do a little rearrangement. But this assumes that the clause authorizes Congress to do what is necessary and proper to carry out the legislative and judicial powers in the abstract. In fact, the clause authorizes Congress to carry out the government's other powers only as they are vested by the Constitution in particular departments and persons. The necessary and proper clause thus carefully avoids authorizing any rearrangement of powers. Fifth, Chevron deference is systematic bias. By the way, this is not the way I teach, because if I were teaching, I'd ask you to answer the questions. This is the way I do exam review, actually. And afterwards, we'll distribute some questions. So Chevron deference is systematic bias. Chevron's a case that requires judges to defer to an agency's interpretation of its authorizing statute. This is the source of much of the worst of administrative power, including the Title IX fiasco. But where the government is a party to a case, Chevron pre-commits the judges to the government's legal position. This is something that no one's noticed in something like 30 or 40 years. But think about it. Where the judges commit themselves to deferring to an agency's interpretation, what they're saying is we're favoring the government's legal position. This is systematic bias. It's barred by the canons of judicial ethics. Judges need to recuse themselves whenever they're about to do this. What's more, it violates the Fifth Amendment's due process of law. In fact, it's hard to think of a greater violation of the due process of law. Sixth, administrative power is not necessary. Necessity has always been the leading justification for absolute or administrative power. But is it really necessary? Well, that's an empirical question. And thus far, there's no scientifically serious empirical evidence of the necessity. None. We've had administrative power for over 100 years, and we have yet to see the empirical proof. The evidence that administrative power is necessary should be relevant textured. That is, the evidence that it's necessary in, let's say, 1890 does not show that it's necessary today. In fact, the evidence that it was necessary in 1990 is not very relevant today because we now have the web and people can protect themselves by just reading. The evidence of the need to license one drug or industry is not evidence of the need to license all drugs or industries, and so forth. Those who depart from the Constitution on theory of necessity have the burden of proving the necessity. Seventh, one version of the necessity argument is that administrative power is a modern response to the complexities of modern society. Maybe, but that's puzzling because, administrative power isn't modern. It revives absolute power. Rulers have always tried to evade ruling through the law and the courts, and whether you call it prerogative or administrative, it's an ancient familiar threat. It's not so much a response to modernity as a symptom of lust for power. To say administrative power is modern is a little bit like saying monarchy is contemporary. Perhaps it is, but I want to fight that. 8, a final philosophical point. We need to focus on the principle of rule through law rather than rule of law. Rule of law is nearly meaningless. It can mean anything authorized by law or even merely law-like commands. By that standard, all administrative law really is law, and we should just submit. The Constitution's principle is rule through law and through the courts of law. Rule of law is thus just a distraction, and we must demand rule through law. In conclusion, at stake is nothing less than the 1,000-year common law effort to establish governance through and under law. In a brief century, administrative power has revived absolutism. It has restored a pre-constitutional, extra-legal mode of governance. This is justified as a modern, pragmatic response to modernity, but in fact, it is the recurring danger of absolutism. Thank you.
The question being addressed by our speaker today is this new form, which it really is, a new method, a new form, is it itself lawful, or is it merely necessitated by modern society? In a new forthcoming book, published by the University of Chicago Press, due out any day now, Philip Hamburger has taken a long view, an older and historical view of this precise question. And he argues that what we face today, this idea of administration, of government rule by regulators, had its origin long ago, and that the resistance to that same thing gave rise to another thing, constitutionalism, which is to say that this is an older and more profound question than merely the latest regulatory move of modern government. Philip Hamburger is the Maurice and Hilda Friedman Professor of Law at Columbia Law School. He writes very widely on constitutional law and its history, and in 2002 wrote another wonderful book on the legal history of the separation of church and state for Harvard University Press. Previously, he taught at the University of Connecticut Law School, at George Washington University Law School, and the University of Chicago Law School. I'm very pleased to have Professor Hamburger with us here today, and I look forward to this talk and his important scholarship, which is coming out soon. Please join me in welcoming him. Thank you.
So, is administrative law unlawful? There are many complaints about administrative law, that it is arbitrary, that it is a burden on the economy, that it is an intrusion on freedom. The question addressed by my book and by this talk is different. The question is administrative law unlawful? Although others have addressed this question in terms of doctrine, my focus is going to be on constitutional history. Those who forget history are doomed to repeat it, and I suppose those of us who don't forget it are doomed to watch others forget it and suffer under the consequences. And this is what has happened under administrative power. Administrative law is commonly defended as new, a new sort of power, a product of the 19th and the 20th centuries, modern power that developed to deal with the problems of modern society and all of its complexity. It thus allegedly could not have been anticipated by the Constitution, and so was not barred by it. My thesis, in contrast, is that administrative power is actually very, very old. It revives what used to be called prerogative or absolute power, and it thus is exactly what the Constitution developed in order to prohibit. Constitutional law developed in order to prohibit absolute power. But we as a nation have forgotten this, and we therefore now suffer under a new bureaucratized version of absolute power. Before beginning, I want to say just a little about historical method. Not the most interesting topic, I know, but it's worth mentioning. First, my focus is not original intent. Instead, the goal is to recognize the original danger, the danger that constitutional law sought to prevent. So rather than focus on original intent, my focus will be on something like a constitutional version of original sin. Second, although the method is historical, the goal is conceptual. One doesn't have to leave with a lot of facts. What one should leave with are a few simple concepts, because I think the history reveals a reconceptualization of administrative law. And so by looking back at the past, we should be able better to deal with the present and the future. To understand what is at stake, I want to begin by explaining what I mean by administrative law. There are many possible definitions, and the one that matters here is historical. Put simply, administrative acts are binding or constraining edicts that come not through law, but through other mechanisms, through other pathways. For example, when an agency issues a rule constraining Americans, barring some sort of pollution or land use, this is an attempt to exercise binding legislative power, not through an act of Congress, but through other sorts of edicts, an administrative edict. Similarly, when an agency adjudicates an administrative violation, imposing a fine or some other penalty, this is an attempt to exercise binding judicial power, not through a judicial act, but again through an administrative act. Now, leave aside for a moment whether or not these administrative edicts are unlawful. What makes them administrative is that they bind Americans not through law, nor through the decisions of a court of law, but through other mechanisms. So you can think of administrative law as a form of off-road driving, right? The Constitution generally offers two avenues of binding power: acts of Congress and acts of the courts, judicial acts and statutes. But the executive prefers to drive off-road, not through statutes, not through judicial acts, but along other administrative pathways. And for those in the driver's seat, this can be quite exhilarating. Of course, for the rest of us, it's just a little unnerving. This understanding of administrative power in terms of binding edicts excludes, of course, much executive action. So when I complain about administrative law, my complaint is not about government benefits or privileges. It's not about welfare or Social Security. And my complaint is not about orders to officers within their constitutional authority as executive officers, for example, in distributing welfare. Instead, the problem consists of attempts to bind or constrain Americans, legislatively or judicially, through acts other than acts of Congress and acts of courts. But on this understanding of administrative power, of course, administrative law is a constitutional puzzle. Our government is full of puzzles, but none are more serious than administrative power. The immediate problem is that administrative power does not match the powers authorized by the Constitution. The Constitution authorizes three types of power, right? Legislative power in Congress, executive power in the president and his subordinates, and judicial power in the courts. But what then is administrative power? A fourth type of power? It's been suggested as much by many of its advocates. But then how is it constitutional? My talk today will lay out two possible answers, and both are framed in terms of history. The first and conventional answer to the constitutional question comes in a conventional or a sunny vision of the history. this conventional vision emphasizes the modernity of administrative law. There are many doctrinal justifications for administrative law, and we can talk about them later if you want, but the foundational justification is that administrative law is modern or novel, and thus without much serious history. From this perspective, administrative power begins in 1887 when Congress creates the Interstate Commerce Commission. And administrative power then just repeatedly expands every several decades in response, it's said, to American society in the early 1900s, 1930s, 1970s, and even more in the last several years. A variant of this account, this sunny, rosy view, comes from Jerry Mashaw, who suggests that administrative law actually is a little bit older, that it began to develop in the early practices of the federal government. But even that account of administrative law maintains the gist of the standard version. The standard history, whether it begins in the 1790s or in the 1880s, is that this is a post-1789 development, a pragmatic response to practical problems in American life. Although it's not mentioned in the Constitution, this sort of law allegedly is in, quote, indigenous and empirical growth, which necessarily arose to deal with the pragmatic realities, again, of American life. It's almost a theological mantra. Well, the conventional vision obviously turns out to be, in this form, very much an apology for administrative power. Sociologically, the message is it's about modernity and necessity. Administrative law is a modern type of power necessary to handle complexities of our lives. It thus is anti-modern and quixotic to resist this power. I guess I'm anti-modern and quixotic, but you may have guessed that. Constitutionally, the message is that administrative law developed after the adoption of the Constitution. Administrative power, thus, allegedly, could not have been anticipated by the Constitution, and therefore, even if it's not amongst the Constitution's powers, it's a necessary and modern addition. It's a very reassuring story, if you believe it. The justificatory implications are powerful. In the conventional vision of the history, post-constitutional necessities slice through the tripartite divisions of power in the government and justify an entirely new approach. In the standard vision, it's a pragmatic necessity for the executive to exercise not only executive power, but also legislative and judicial power, all three in one branch. You know, look, Ma, no hands. I can do it all in one. It's in the standard vision, it's a pragmatic necessity to adjudicate disputes without judges and juries. If an agency can even be a prosecutor, judge, and jury. In the standard vision, it's a pragmatic necessity for the due process of law and indeed all procedural rights to be put aside when you adjudicate in the executive branch. This is, they say, all the process that is due. And in the standard vision, it's a pragmatic necessity for judges to defer, not exercise independent judgment, but defer to executive interpretations of law, and so forth. You know the rest. But there are problems with this conventional history and its justifications. And the most basic question concerns historical accuracy. Is it true that administrative law is a modern, post-constitutional American development? Is it true that the Constitution could not have anticipated administrative law and did not prohibit it? Ultimately, this conventional history I propose does not dig deep enough. It is a cheerful, breezy vision of history in which the past is not examined too lightly and all is sweetness and light. So let's turn to a second vision, a much darker vision, which looks below the surface of the usual apologetics and sees a very dim and dismal past. In fact, administrative power revives absolute power. Rather than a modern necessity, it is a version of a recurring threat, one inherent in human nature and the temptations of power. The constitutional history of the past 1,000 years, in common law countries at least, records the repeated ebb and flow of absolutism on the one side and law on the other. There always have been pressures for absolutism, and law only sometimes has been able to resist. During the next 10 minutes or so, we will examine the history of absolute power. And as I recount it, please think about the modern parallels. I may be talking about medieval or 17th century kings, but you should be thinking ahead of me about contemporary presidents, and not just the current president, the last century of presidents. We need to begin with prerogative power. English kings were widely expected to rule through law. They had parliament for making law and courts of law for adjudicating cases, and kings were expected to govern through the acts of these bodies. Thus, to bind their subjects in general, they needed to seek acts of parliament, and to bind their subjects in particular cases, they needed to go to the courts for acts of the courts. But kings were discontent with governing through the law. They wanted more than they could get when going to the legislatures and courts. And they often acted on their own, not through law, but through royal or prerogative power. The power ordinarily exercised through law thus was evaded when kings acted through prerogative power. Prerogative power thus was the predecessor of administrative power. Prerogative power was the personal power of kings. Administrative power is the bureaucratized power of states. But otherwise, they are similar. They both have been evasions of law. Consider these prerogative evasions, and they should sound familiar if you have any experience with administrative law. Ordinarily, kings bound their subjects through statutes, but through their prerogative power, they bind subjects through proclamations or decrees, what we call rules or regulations. Ordinarily, kings repeal old statutes by obtaining new statutes, but through their prerogative power, they issued prerogative dispensations and suspensions, what we call waivers, right? Ordinarily, kings could enforce the law only through the courts of law, but with a prerogative power, they enforced their extralegal commands in their own prerogative or extralegal courts, notably the King's Council, the Star Chamber, and the High Commission, where the due process of law gave way to inquisitorial process derived from the civil law, what we call administrative process. Ordinarily, judges resolve disputes about royal power in accord with the law and their own independent judgment. But on account of the prerogative power, kings expected deference from judges. They expected deference to prerogative regulations, to prerogative interpretations of statutes, what we call the Chevron problem, and deference to prerogative fact-finding, the administrative record. Interestingly, though, 17th century judges refused to defer on the whole. Something has changed. Last but not least, prerogative power evaded English divisions of power. They did not yet have a full separation of powers, but they did have a basic division of powers. Parliament had power to make laws, the law courts had the power to adjudicate, and the king had the power to exercise force. It isn't that different from what we're familiar with. Nonetheless, when kings acted through their prerogative power, they, or their prerogative courts, what we call their administrative agencies, exercised all government powers in one. For example, the Star Chamber could make regulations, prosecute infractions, and adjudicate them, all in one agency. Evidently, prerogative power was a means of evading government through law. And just as kings evaded law with prerogative power, the executive now evades law with administrative power. The defenders of this sort of prerogative or administrative power described it as absolute power. This is not an accusation. This was their defense. This was their justification. They were proud of it. Of course, the phrase absolute power can have many meanings, but it once was used in very concrete ways to describe the prerogative or administrative power that evaded the law. Precisely what made this power absolute? Here we get to the conceptual payoff. Conceptually, there were three central elements of absolute power. Absolute power was extralegal, supralegal, and consolidated. First, absolute power was extralegal. It was extralegal in the sense that it bound the public not through law, but through other sorts of edicts. For example, when kings bound their subjects not through statutes, but through prerogative decrees, rules, regulations, they acted extralegally, not through law, but through another means. When kings made adjudications binding their subjects, not through the acts of the law courts, but through prerogative adjudications, they acted, again, extralegally. Thus, the first way in which prerogative, or today administrative power, was absolute is that it was an extralegal power, exercised not through law, but outside it. The second absolute element of power was that it was supralegal. It was supralegal, and by the way, these terms turn up amongst medieval philosophers. I'm not inventing these terms. These were the terms they used. It was supralegal in the sense that kings expected judges to defer to it. Judges had a duty to exercise their own independent judgment in accord with the law of the land. They could not defer to others. Parliament even passed statutes requiring them to take oaths not to defer to the king or the king's letters. This was a strict requirement already in the 14th century. Kings, therefore, could not impose extra legal power unless they could evade review in the courts. And kings, therefore, insisted that much of their prerogative was above the law, that it was supralegal. And from this perspective, because it was above the law, judges, they said, had to defer to the prerogative decrees, the prerogative interpretations of statutes, and prerogative adjudications. Deference to prerogative or administrative power thus depended on this power being supralegal. And this is the second way in which it was absolute. Again, it sounds familiar, doesn't it? Third, absolute power was consolidated. It was consolidated in the sense that it united all government powers in the king or in his prerogative courts, again, what we call administrative agencies. When prerogative or administrative bodies made law, adjudicated, and executed it, they obviously were combining all powers of government in one. Prerogative or administrative power thus could be absolute in three basic ways: extralegal, supralegal, and consolidated. Underlying these three elements was the usual conceptual justification for absolute power: necessity. Necessity, it was said, has no law. It thus stood apart from the law, and it rose above it. It therefore was the repeated justification for extralegal, supralegal, and consolidated power. So whereas common lawyers rested on the law of the land, the king attempted to evade and defeat claims of law with claims of necessity. Let's look at some historical examples. Much of the history of the common law can be understood as repeated responses to absolutism. When King John calls Englishmen to account extra-legally in his council, not through the courts, but just in front of him and his bureaucrats, the barons in Magna Carta in 1215 demand that no freeman shall be taken or imprisoned or deceased, nor will the king send for him, you can't even send a summons, except by the lawful judgment of his peers or by the law of the land. When 14th century English kings questioned Englishmen in the king's council, Parliament in 1354 and 1368 enacts the first due process statutes, requiring the king to act through the due process of law. This is, again, the same issue we face today. When 14th century kings, when James I attempts to make law extra-legally through proclamations, it's the early 17th century, the judges respond in 1610 with an opinion that binding proclamations, executive acts that attempt to bind people like a statute, were unlawful and void. When James demands judicial deference to prerogative interpretations of statutes, it's one of his pet concerns. He wants what we call Chevron deference. The judges refuse. They don't go along with it. Indeed, in 1641, Parliament abolishes the prerogative courts, the Star Chamber and the High Commission, which are the bodies that engage in extra-legal lawmaking and adjudication. And most profoundly, the English defeat absolute prerogative power by developing ideas of constitutional law. The English Constitution, of course, was lost in the mists of time, if it ever really existed, but it was said to be the source of all government power, and it was said to place legislative power in the legislature and judicial power in the courts. The Constitution, therefore, made clear that there was no extra-legal, supralegal, or consolidated power. And the U.S. Constitution echoes all of this. It echoes this response to absolutism. Early Americans were very familiar with absolute power. They feared this extra-legal, supralegal, and consolidated power because they knew from history it could evade all law and all legal rights. And it therefore is no surprise that they framed the Constitution to bar this sort of power. To be precise, Americans established the Constitution as the source of all government power, and they used the Constitution to place legislative power in the legislature and judicial power in the courts. There thus could be no extra-legal, supralegal, or consolidated power. Well, but that's changed. Nonetheless, absolute power has come back to life in common law lands. After absolute power was killed off in England and America, it circled back, oddly enough, from the continent, through Germany and especially Prussia. Although extra-legal power was defeated in England and America, it survived and flourished in civil law countries, most prominently in France and Germany. There, what once was the personal prerogative power of kings became the bureaucratic administrative power of the states. And the Prussians were the leader of this development in the 17th and 18th centuries. And in the 19th century, they become the primary theorists of administrative power. And they celebrated, they didn't hide, they celebrated its absolutism, and they celebrated its defeat of constitutional law and constitutional rights, which they mocked. And strangely, this was the source of American administrative law. Thousands upon thousands of Americans studied administrative power in Germany. You couldn't get a job. I teach at Columbia University. You could not get a job teaching political theory in Columbia unless you had studied German administrative power. You had to actually go to Germany, and most actually had German degrees. Now, this studying of German law was not enough to revive absolutism, but at the same time, progressives were becoming increasingly discontent with elected legislatures and independent courts. This, in fact, was probably not a political matter, but a class matter, but that's another matter you can read in my book if you're interested. Progressives increasingly sought to evade rule through and under law, and they therefore embraced German theories of administrative power. They adopted absolutist theories of extralegal lawmaking and adjudication, absolutist theories of deference to superlegal power, including interpretation, and absolutist theories about consolidated state power. And they justified all of this by insisting that necessity defeats law, especially constitutional law. The progressives, moreover, understood what they were doing. This wasn't a hidden agenda. They taught this in our finest universities. And as late as 1927, after many of them had begun to go quiet on the subject when they realized it was politically unpalatable, even John Dickinson writes in 1927, the question of whether or not the king can issue ordinances parallels our modern question as to whether or not an executive body or officer can establish regulations. And the arguments pro and con have followed much the same lines. Again, he knew exactly what he was doing. There thus is a direct intellectual connection between medieval absolute power and modern administrative power. It's not merely a revival, it's the same thing, the same intellectual tradition which circled back from the continent. So what the English defeated in the 17th century, and what Americans rejected in the 18th century, Europeans, and especially the Prussians, preserved and developed, and from there Americans reintroduce it back into America. Absolute power, thus, has been continuous, and although it once was defeated by constitutional law, it has come back and triumphed. Over the past 120 years, Americans have reestablished the very sort of power that the U.S. Constitution most centrally forbade. Administrative law, I'm repeating myself perhaps, but it's worth driving home. Administrative law is extra-legal, in that it binds Americans not through law, but through other mechanisms, not through statutes, but through regulations, not through decisions of courts, but through other adjudications. It is superlegal in that it requires judges to put aside their independent judgment, the very office of being a judge, and defer to administrative power, once again bowing to it as if it were above the law. And it is consolidated in that it combines the three powers of government and administrative agencies. Absolutism has returned. This dark vision of history has powerful constitutional implications. In general, the history shows that the Constitution barred this extralegal, superlegal, and consolidated power. Regardless of whether you call it prerogative or administrative, this is what the Constitution most centrally forbade. But the history is also power when we get into specifics. And I therefore want to close this talk with some examples of how the history sort of darkly illuminates some familiar constitutional problems. There are many possible examples, and you can read about them in my book because I think they'd be useful in litigation, amongst other things. But it should suffice to discuss two of them, delegation and procedural rights. One standard defense of administrative power is delegation. For example, it is said that Congress delegates its lawmaking power to administrative agencies, and they then use this power to promulgate regulations. From this perspective, it does not matter that the regulations are extra-legal because Congress has delegated its lawmaking power. But this is a very poor defense. In the past, the delegation of lawmaking was actually a familiar feature of absolute power. This is not something newfangled that solves the problem. When kings exercised extra-legal power, they usually had at least some delegated authority from Parliament, or at least an ambiguity they could run with. For example, Henry VIII issues binding proclamations under a statute he obtains called the Act of Proclamations, which authorizes him to do this. Yet even with legislative delegation, his binding proclamations were understood to be exercises of absolute power. And in centuries later, particularly the 18th century, the Act of Proclamations is condemned as unconstitutional. David Hume, no Whig, says this: when Parliament gave to the King's proclamation the same force as a statute enacted by Parliament, it made by one act a total subversion of the English Constitution. The delegation of legislative power thus was a familiar aspect of absolute power. How does the Constitution respond? It expressly bars the delegation of legislative power. I know that may seem odd to those of you who may have studied this. It's widely said, for example, by Cass Sunstein, that the Constitution does not expressly bar the delegation of legislative power. But read the Constitution, indeed the first words. The Constitution's very first substantive words are, all legislative power herein granted should be vested in Congress. The very first word, all, precluded delegation. You see, if all legislative powers are in Congress, none of them can be elsewhere. It's not an accident that the word all was put there. It was put there precisely to bar delegation. Evidently, the delegation of legislative powers was a familiar problem, the most serious of problems, and the Constitution responded by expressly barring it. There's a lot more that we can say about delegation, but let's leave that aside and move on to one other example. A second constitutional problem illuminated by this dark vision of history is the administrative denial of procedural rights. Administrative adjudication evades almost all of the Constitution's procedural rights. It offers some minimal protections, but even in cases that are criminal in nature, it subjects Americans to adjudication without real judges, without juries, without grand juries, without full protection against self-incrimination, and without other due process of law, and so forth. You can just run through the Bill of Rights. Indeed, like the old prerogative courts, administrative courts substitute inquisitorial process for the due process of law. And by the way, that's not just a vapid, general, abstract accusation about inquisitorial process. It's exactly what a lot of early administrative law was deliberately modeled on. And so administrative adjudication becomes an open avenue for evasion of the Bill of Rights and procedural matters. The standard justification is that procedural rights apply centrally to what the government does in courts, not entirely to what the government does in administrative areas. In fact, it's only through the generosity of the courts that we get some little protection in administrative matters. Hence the famous perversion of due process, that administrative agencies provide all the process that is due. Isn't that funny? But the history shows that procedural rights developed primarily to bar prerogative or administrative proceedings. Not on the side. It was the main focus. Not merely to regulate what the government does in the regular courts of law. The principle of due process of law, as I already suggested, develops as early as the 14th century in statutes which attempt to prevent the exercise of judicial power by the King's Council. It's not about the law courts primarily. It's about what happens outside the courts. Englishmen developed due process into a constitutional principle in the 17th century in opposition, again, to the prerogative courts. It therefore is clear that the due process of law essentially barred extra-legal adjudications, not merely wayward adjudications in court. Similarly, just take another example of these procedural rights, the right to a jury develops primarily in opposition to prerogative or administrative proceedings, not merely as to court proceedings. One of the problems with prerogative adjudication in the 17th century is that it denies defendants their right to a jury, right? That's one of the complaints about it. Early Americans understand this danger of administrative proceedings, and indeed some of the very earliest constitutional cases in the United States are on the subject. In New Jersey in 1780, in New Hampshire in 1785, the regular law courts hold administrative proceedings before justices of the peace unconstitutional, precisely because they do not offer juries. The denial of a jury, like due process, is all about administrative matters, although it also includes what happens in courts. The dark history thus powerfully illuminates the constitutional problems. It shows that the Constitution barred any delegation of legislative power, and that the Constitution guaranteed due process and jury rights, most basically to bar administrative adjudication. Again, there are many other examples. You can read about them if you wish, but these, I think, should show the central force of the historical analysis. Now, in conclusion, the sunny, conventional vision of the history is utterly mistaken. It misses the entire pre-constitutional history. It misses the danger of extra-legal, super-legal, and consolidated power. It misses the recurring and dangerous character of absolute power. It misses how courts, constitutions, including the U.S. Constitution, systematically barred absolute power, whether prerogative or administrative, absolute power was forbidden. If we are to understand administrative power, we need an accurate history of it, an accurate conceptualization of it, and an accurate vocabulary. The first step is historical. We need to recognize the place of administrative power in the long history of absolute power. On this basis, we can begin to see the danger and can begin to respond. Absolute power was the danger that led to the development of constitutional law. We therefore can see how the Constitution barred this threat and how it is unconstitutional. The second step is conceptual. We need to recognize administrative power as extralegal, superlegal, and consolidated. On this foundation, it becomes apparent that administrative power is utterly incompatible with constitutionalism and with the ideal of rule through and under law, not the vague general notion of rule of law, but the core common law ideal of rule through and under law. And the third and final step in this reconceptualization is to change one's vocabulary. Administrative power has thrived in America because its proponents used the vocabulary of law to legitimize an extralegal enterprise. Therefore, to recognize the realities of administrative law, one must take back the language of law. One must reject the current legitimizing vocabulary and use more accurate words which acknowledge the grim realities. Administrative power seems lawful when you speak, for example, of administrative law. Even I've been doing that, right? We speak about administrative courts, or administrative law judges, or administrative due process. To be accurate, we have to speak more clearly, not about administrative law, but about absolute power, including extralegal and superlegal power. Not about administrative courts and judges, but about executive officers straying outside their constitutional authority. And we cannot talk about the process that is due, or due process in administrative circumstances, but about the administrative denial of due process. Only if we're honest in our very words can we begin to address the danger. So at stake here is nothing less than the 1,000-year common law effort to establish governance through and under law. In a brief century, administrative power has revived absolutism. It has restored governance outside and above the law. This gets justified as a modern pragmatic response to modernity, but in fact it is the recurring danger of absolutism, of extralegal, superlegal, and consolidated power. Thank you.
Dr. Hamburger would be glad to take some questions. I just want to ask one quick one to start. Isn't the fact that there's been such growth in administrative law and the fact that the government is working so well today, isn't that just evidence for its efficacy? I mean, those of us who've been in line at the TSA, I think, would have to disagree with you.
Yeah. More and more is better. It's like ice cream. You just can't get enough. It's actually interesting to listen to some of my colleagues who I would generally identify as liberal or left, describing administrative power precisely along these lines. They say, we have so much of it. It must have been adopted for a reason. It must be good. And then when you point out to them that you cannot think of a more conservative, indeed retrograde mode of arguing, that in fact you're just defending the status quo, they pause because they realize that in fact that's not how they identify it. So yes, that's right. We should press this point.
John Stossel.
In your ideal world, how would this work? People assume there are some things in the modern state that these agencies have done that they like. I can only think of maybe one. But the EPA, which you mentioned the extremes, but until it became what it is now, it got the air cleaner, it got sewage treatment plants built. How would this get done properly?
Right, and I assume you're not talking about the Colorado River or Flint. Yes, but take this seriously. You're absolutely right. There's a lot of regulation that's actually very useful. We don't always know which the useful regulation will be, but undoubtedly some regulation is very, very valuable. So the question is really not what regulation, but how it's adopted, right? Now, who would do this? I don't think we really need the EPA, but we don't need to abolish it. The EPA could simply study the matter, and with all their expertise, which I actually think is dubious, but if they had the expertise, they could give advice to Congress, and Congress could simply enact regulations proposed by the EPA. We do not have to abolish a single agency to get to where I want to get. All we have to do is to have the laws enacted by Congress and adjudications happen in courts. So to just give another example, the FDA can advise Congress on which drugs need to be licensed, and Congress can do it. Congress can do it very quick, in fact, much faster than the agencies can do it if it wants to. The obstacles are political, not technical. Thank you. I hadn't thought of you as a legal realist. It's an interesting problem, isn't it? Our institutions, Congress and the Supreme Court and the presidency, all three branches of government, have served this up to us and told us it's lawful. And in those circumstances, what hope is there of pushing back? One might just say, give up and accept it. But you know, if I were being mugged, I don't think I would just give up and accept it. I don't think anyone in this room would do that. And nothing's forever. We're told that this is somehow as solid as this table and it cannot be moved. But you know, everything can be moved. So I'm not that worried. The Supreme Court, in fact, I think is already rather worried. The Supreme Court, for example, gives us the Chevron deference on the assumption that somehow the judicial power can be shifted from where Article 3 places it into the place where Congress has put it. But actually, beginning 2 years ago, I'm glad to say, in response to my arguments, they have doubts. They've now hesitated to apply Chevron deference in the last year and a half. I think that's very encouraging. In other words, it's a great mistake to give up. Just because Congress wants to give away the power the Constitution places in Congress doesn't mean Congress can't be reformed. But personally, my path will be through the courts. And I'm hoping to actually to form an organization to litigate, to persuade the courts to back off. And I'm actually more optimistic than you may think. Thank you.
Yeah, thanks for your inspiring talk. Please elaborate on what you just said. I noticed, for example, that your book is very respectfully referenced in Charles Murray's book, in which he's got a big plan. I gather you're somewhat critical of his plan, although you guys are obviously on the same team. But what is your plan of action? I gather you have one. Tell us all about it.
Okay. I have great respect for Charles Murray. I know he's much smarter than I am, amongst other things. But I think his plan was not thought out from a lawyer's point of view. His plan was to spend $100 million, which I don't have, to defend everybody hurt by administrative power, which would cost a lot more than $100 million, and I think would be a losing proposition. I think instead one has to be a little more agile. What one needs are to look for the chinks in the wall, the places you can crowbar in to loosen up a brick and then another brick and so forth. And the weak points, and I think it's very important not to litigate as has been in the past, which is defensively and very political cases. Instead, one has to look for the types of power that you can take down and thereby cripple administrative law across many agencies. And so the key is to look for the weak points where you can get to certain types of administrative power. Now, where are those? It's no secret, I generally don't like to talk about litigation strategy in public, but it's no secret what my views are about the first step. One of the first steps is Chevron deference, which is why I've been fighting that. It's really Chevron bias, as I explain in an article. And that should make the judges nervous. The judges are a weak point in the system because they care about their integrity. They care about their judicial independence. They don't like being told that they're biased. And in this instance, there's really no response they can give. Now, I don't want to actually litigate this. What I'd like, rather, is to have the judges just become worried that they might be asked to recuse themselves. One has to be delicate and respectful of their sensibilities. They're serious people doing serious work, but I want them to reconsider. And I think one can get them to reconsider on all administrative bias. So that's a first step right there. A second step, I think, seems to me, is to litigate on free speech issues. The judges are pretty good in free speech, and a lot of administrative power these days is used to control speech. For example, my speech, if I were to ask one of you a question without getting prior permission from a censorship board, I will be fired. It makes McCarthyism look like small potatoes. That's courtesy of HHS, which views speech as a health threat. So that, I think, is begging for litigation. I can't wait. And that will be particularly delicious because, in fact, that sort of censorship is used to control science throughout this country. We think we have a lot of scientific freedom. We don't. My interest in this began when I was sitting around at a friend's house, and he said he couldn't publish a statistical article, and she, a distinguished scientist, couldn't actually look at the tissue banks to save the lives of children because there was just too much bureaucracy. These censorship boards are stifling science. We'll all live 10 years longer if we kill off these boards. So medicine will be freed if we do this. So those are the first steps. I could go on, but I think you got the idea. There are weak points, and we should go for the weak points.
Well, thank you very much for those most inspirational remarks. I have a couple of quick questions. First of all, Congress, for example, with the Department of Labor, said that it expressly delegated the authority to say when white-collar workers have to be paid overtime. The Department of Labor has just doubled that ceiling to $47,000, so white-collar workers paid under that have to be paid overtime and keep track of their hours. But lawyers don't see how they can fight that because Congress expressly told the Labor Department to do that. So how would you treat that? And second, with the Dear Colleague letter from the Office of Civil Rights, if it's a guidance letter, is it legally binding anyway? It didn't go through the regulatory process. It didn't get comments. So is it really legally binding the way a regulation is?
Right. Those are very interesting questions. So first of all, on expressly authorized rules, first example you gave, that's the last thing I want to litigate. I think one has to build up to that. And I wouldn't want to litigate that case. I'd want to litigate a very apolitical case. But you're absolutely right, that's the core. But that core has to be approached carefully. One wants to work step by step. So the order in which one does things really matters. And then as to guidance, right, it's really rather odd. Government by raised eyebrow is the phrase that I've heard in respect to this. The government actually doesn't have to tell you what they want. They just have to make you fear. At least with the guidance, they tell you. Sometimes they don't even tell you. This is very dangerous stuff. And the question then is how to approach it. I think if one cannot, one of the beauties of attacking Chevron deference first is it clearly involves deference by the judges. They proclaimed this, and it makes them look awfully biased. Once Chevron deference falls, then you move on to our deference, which is deference to agency interpretations of regulations, and then one moves to the guidance. Because if we can kill off the more formal forms of deference to agency positions, then I think guidance follows, right, sort of inevitably. It's very hard to litigate on the guidance issues for a host of technical reasons, and which is why I think one has to begin with the other cases. But yes, it's very dangerous, very, very dangerous stuff.
Thank you. Is expansion of administrative power a problem at the state level as well? And how are the states responding to the federal government's expansion of administrative power?
This is a source of both despair and amusement for me. Yes, the states are awful, some of them, just awful. And some are particularly awful. Virginia, you would have thought Virginia, which has 2 separation of powers clauses in its constitution since 1776, would be a good state, but no, they added a special administrative power amendment which authorizes all administrative power. So the states can be just as bad, if not worse. So what I've been talking about is mostly federal power because it's cleaner there. And so, right. So that's the hope. It seems to me the states are going to be a source of great inspiration. The states have some remarkable lawyers, and one of the joys of the past year is been traveling around getting to know them. And some of the states are pushing back for federalism reasons, and these folks understand administrative power. They want to work against it. And this will be a very beautiful thing to watch. I don't want to go into detail, but it gives me great hope. These are remarkable lawyers, and they understand it, and they have an axe to grind because their states are being destroyed by federal administrative power. But just to give you a sense of how dangerous it is for them, the Supremacy Clause says that if you have an act of Congress, that will trump a state statute. Okay, fair enough. That's federalism. But now, an administrative interpretation trumps a state statute, and this grates rather harshly on the idea on some of the states. Thank you.
Thank you very much.
very much.